everybody. Welcome to this workshop, this webinar talking about the MPT, the multi-state performance test. My name is Maureen. I am the founder and creator of BarMD. We're a full service bar prep company. So anything you need to prep for the bar exam, whether it's UBE or California and even some of the other jurisdictions, we can assist you. I've got a lot of people in Georgia that use our PT resources in particular, and our MBE resources as well. Everybody, let me know, just because I'm always curious, where you are taking the exam. What jurisdiction are you taking? Tell me in the chat. It's always just good to know. DC, Oklahoma, Indiana, New York. I'm in New York. I'm in New York from California, but Texas forever. I love Texas. I was just there and over in West Texas. We got some Arkansas, got a few Arkansas, got quite a few New York. It's typical. Hey, Lawrence. Welcome. All right. Ooh, Montana, one of my favorite places. So we're going to get started. DC, I always get a lot of DC, Colorado, etc. So let me just get this on the screen the right way. So let's get started. Oh, Vermont, very nice. All right, so goals for today, we're going to really focus on the PT process. We're going to talk about how the PT is written and put together, and also how to organize a performance test. We're going to talk about how to organize. So first, I just want to plug, because we're all here, I just want to plug some really good tools for the PT. So first, if you guys haven't taken it, my Mastering the Performance Test course, it is not too late to start. It's absolutely not too late to start. You can definitely do it and complete it and get really great at the PTs starting now. So I'll put the link to that in the chat. And we're actually going to have a little discount code for those of you that are here that are attending live at the end of class that you could use on that. We also have the best PT book that I wrote, which you can check out here. I just put the link to that as well. So it covers, I think there's 12 MPTs that are fully deconstructed with my model answer, and where I really walk you through every step of the PT for a bunch of the different PTs, for objective and persuasive, etc. So people love that book and the class. The class has actually been revamped entirely for the upcoming, for February 2025. So definitely check that out. And then we have this thing that is new called Checkups. These are mostly on Sundays. Like I have one this coming Sunday. They're $25. And what it is it's a session where you join, and you get 3 hours that we proctor to write 2 PTs that we give you. So we'll give it to you about 48 hours in advance. And that way you can print them out, have your hard copies available. So we're going to proctor it. It's 3 hours, and then you take a short break, and then I'm going to be there to teach you and walk you through these 2 PTs that you're going to do, and you'll get a model answer and all of that stuff too. So those are $25. They're really inexpensive, in the bar prep world in particular. So I'll drop a link to those as well. And it's the Checkup 3 that's coming up. So just as a heads up on that. So just some good tools are there. So first, I want to just walk through the PT process, and then we're going to go through some of the steps here together. And just as a heads up, I'm going to talk through this process, but I do have some videos on YouTube as well where I'm going to go in depth on different things. So you should definitely check out what we have on YouTube as well. And if you're not in our free workshops, if you're not a member of that, I'll put a link to it, because it's like a full lecture with a model answer as well that you can get access to. Did you guys see the links I put in the chat? You guys can see all those. So the very first thing you do is you review the task memo. When you review the task memo, there are 5 things you want to pay attention to. So let me actually pause for 1 second. Somebody asked what time the checkup sessions are. They start at 4 p.m. Eastern time. Mostly on Sundays, there's one Saturday, which is the 15th, 16th. To basically make, there's one Saturday session. But yeah, they start at 4 p.m. Eastern, 1 p.m. Pacific. So the first thing you do is you always review the task memo. That's that first substantive document after the instructions that is within the file. And when you review the task memo, you want to identify 5 things. There's 5 things. You want to identify the tone, What's the tone? Is it objective? Is it persuasive? Is it a mix? Is it something else? It should be either objective or persuasive or a mix of the two. Then you want to know, who's your audience? Who are you writing to? Are you writing to your client? Are you writing to opposing counsel? Are you writing to the court? Are you writing to your boss? Who are you writing to? So you want to know that. You want to know what the product is that you are preparing. And there are 5 really common tasks that you should be familiar with and know how to do. So there's really 2 common objective tasks and 3 common persuasive tasks. The 2 objective tasks are memos, so just like a memorandum to your boss, and a letter to your client. Generally speaking, unless told otherwise, if you are writing to your client, you're writing objectively. So you might take a position, but you're not trying to convince someone that your position is correct necessarily. The 3 really common persuasive tasks are a brief, which is also called a memorandum of points and authorities. So those terms can be used interchangeably. So even though the word memorandum is used in that, it's actually a persuasive document because it's a memorandum of points and authorities for a brief that you're submitting or for a motion. Another common persuasive task is a letter to opposing counsel. A letter to opposing counsel. And the 3rd common persuasive task is a closing argument. People are constantly thrown off by a closing argument, but it's basically the same as the others. It's just that your introduction is a little bit different. It's just, may it please the court. And then you basically proceed in the same way that you would do any other task. So tone, audience, what's the product that you're preparing? 4th that you want to know is, how are you going to organize the substance of your PT? That I don't get into a ton of depth here, but generally speaking, every PT has an introduction, analysis, or argument section, which is the meat of your task, and a short little conclusion. The intro and the conclusion we don't really care about. It's just like 1 sentence each if you do them at all. It's kind of nice to have them, but if you're someone that always runs out of time, that's usually one thing I say to cut. But if you can include them, they're nice. But in the argument, if it's persuasive, or in the analysis section, if it's objective, then you want to know, well, what are your headings? So you're going to have subheadings in your PT. And what are those? What issues are you addressing? What are the issues? What are your subheadings? What does it look like? So that's how you're organizing your subheadings in the meat of your PT. And finally, the last thing is, are there any special instructions, such as a particular way to write your headings? If you have to include a statement of facts, if there is an issue they don't want you to address. So you really want to look at that stuff. So those are the 5 things you want to identify in your task memo. And once you've identified that, you're going to do your setup. And this is directly in your exam answer. So if you are typing the exam, you're typing into the answer. If you are handwriting, you're going in the blue book, right? You're going in your blue book. And if you have 3 issues for handwriters, if you have 3 issues, you should have 3 blue books, right? If you have 4 issues, you should have 4 blue books. So handwriters, get extra blue books at the outset. Ask for extras. So step 2, and you get about 5 minutes. This is assuming you have 90 minutes, so you don't get accommodations. If you get accommodations, you need to, modify the times accordingly. So step 2 is you're going to set up your outline. You're basically just going to input your headings and your subheadings to the extent that you know them. So you're going to include them. This is also when I very quickly draft an intro and draft a conclusion. If you don't know your organization yet, if you don't know your organization after reading the task memo, and we won't after this one, which is why I picked this PT, then you've got to figure out what that is. So if you have a hint as to how to organize, then you want to go to that next. So now we're about 10 minutes in with the PT. So then we're going to skim the file. Skimming the file is really quick. We're just seeing, does anything jump off the page in the file this just stands out to give us a sense of what's going on in our case. Step 4 is where people tend to get bogged down a little bit. Step 4 is where people tend to get bogged down. So this is where you skim and read the library. And why do I say skim and read? You're not skimming the whole thing and then reading the whole thing. With each If I have statutes at the start, I'm just looking at the headings of each statute to get a sense of what I have going on to start. I tend to read in full any statutes at the end after I've read the cases, because the cases write rules much easier than the statutes do. So I'm going to look at the headings in the statutes. I'm not going to worry about all the substance of the statutes yet. I just want to know, what do I have? And then I'm going to go to the cases in the library. And I'm reading every case with purpose, trying to place it to the appropriate issue. So I'm trying to place it. I'm trying to identify, where are my rules? Where is the analysis that this court does of the actual rules and applying them to the facts of the case? So I'm not focused in the first couple of paragraphs. It's usually a couple of paragraphs of where they're just going over all of the facts. And we skip that. So I say skim, and I'm going to demonstrate this a little bit, but I say skim a case until you get to the procedural history, and then you start to read that case. Because after the procedural history is where you're going to get the rules and you're going to get the court's analysis. So we want to identify the rules, be able to place which issue this case is going to be used for, and identify what does the court say about this issue. How did the court apply the rules that they give you in the case, or to the statutes that, that are in the case, and also in your library, ideally, or possibly. How do they apply those rules to the facts of the parties in the case? So assign the case to the appropriate issue. And if a court goes in depth on a particular issue, they're analyzing something. So maybe, for example, they're talking about, maybe you're dealing with a negligence issue. And the court, we know negligence is duty, breach, causation, damages, right? But maybe all the court is really talking about is whether a duty is owed, and if so, what is the applicable standard of care, right? So maybe that's all they're talking about in the case. Then we're trying to say, okay, so this case focuses on duty and standard of care. So if I'm going to have an issue dealing with duty and standard of care, I'm going to use that case for that issue, right? I'm matching this. If it's Smith and that's my first issue in my PT, I'm going to match Smith to issue 1. And I'm going to make a note of that in my answer, which I'm going to show you all how to do this in a minute. So assign the cases to the appropriate issues, and you're going through the entire library that way. Then after you've gone through the whole library, you've read through the cases, and you've gone back, if you have statutes and you've read through the statutes, then I'm going to start typing in my answer, and I'm going to draft and just copy in the rules. And I'm going to draft a rule proof, which is I give you my formula here. Under 0.5, where I just say, in this case, and this is not something that is written, you have to construct a rule proof from what they give you in the analysis section of the case. So when they say, in whatever the case name, in Smith, the court held the defendant owed the standard of care they owed a standard of care because they were a landowner, and the plaintiff was an invitee. So the standard of care, or what they should have done, is they needed to install street lamps and have security guards in their place. That's what a reasonably prudent business would have done. So that's under the relevant standard of care. To act as a reasonably prudent person, that's what they would have done. So maybe that's all the court talks about. So I'm gonna write that. So I use this formula every single time. Literally, I do not stray from this, or very, very rarely do I stray from this. So steps 4 and 5 is usually where people get bogged down. How many of you guys have a timing issue? Tell me in the chat. Do you have a timing issue where you tend to run out of time? Yeah, if it's a timing issue, it's something that really has to be worked on, and it's really in steps 4 and 5. One of the biggest tips I have for people that get bogged down with the time, especially with my structure, is 1, don't skim the file. 2, cut the intro and the conclusion. Yeah, so there's those things. Also, really, when I'm in step 4, all I'm really trying to do when I'm in step 4 is say, what issue does this go to? What issue am I going to use this for? I'm not trying to have a really solid understanding of the rule per se. That's at least for me. Some people can't do that, and that's okay. But I'm just saying, okay, I know I'm going to use this rule here because it's talking about this issue, and I'm going to use this other rule over here. For example, And I'm not going to have a great understanding of everything. Where I get the understanding is basically when I'm kind of, when I've said, okay, I'm going to use the Jones case for issue 1, and I've got it marked in my PT. I have it marked, in the library where the rule is. So when I'm copying in the rule, and I basically copy rules verbatim, I'm trying to really type and understand it then. So that's what I do mentally. And when I'm drafting my rule proof, I always use this formula. And it is not the rule proof. This has been a point of confusion for people, is that they think that the rule proof is something that is written in the case. No, it is something you construct with the information in the case. So it's something you construct. After that, you read through the file and you write your analysis. I'm not going to really get into the writing of the analysis today. I have done that in other workshops that you can see on YouTube. It's also, I go really in depth into it in my book and in my class. And then time permitting, you're going to proofread. Truthfully, it's really like 1 to 2 minutes where you can proofread. And really, I'm really looking at like my headings. I don't like people to, if you spend a lot of time, if you get stuck on time, something to watch, a huge thing to watch out for is, do you spend a lot of time correcting typos? Perfection is the enemy of completion. So you cannot afford to be a perfectionist. All a PT is an okay first draft. That's it. You can absolutely write an answer that has typos in it and get a high score. That is completely okay. The cutoff is where it's hard for me to understand what you're saying, or I'm really distracted because there are so many typos. And I will like bar graders have been grading generally for a long period of time. They are used to the normal typos. If you write TEH instead of THE, I know you mean the, right? But like, if it's just so riddled with errors that I just like have a hard time understanding it, that becomes problematic. That doesn't happen all that often. So do not spend a ton of time fixing typos. Perfection is the enemy of completion. I want a complete PT, not a perfect 2/3 of a PT. So that's the battle for a lot of people. In my PT book, there are, I think 12 or 13, I think, things in there. And in my PT book, I think my average score depends, but mine are a high pass. So if you're on a 1 to 6 scale, I would say mine are probably a 5. They're not a 4, they're a 5, but they're not a perfect answer. They're not a 6. If you're in New York, which does like a 20 to 80 scale, mine are probably like a 65-ish, 65, 70 on the New York scale. California, mine are like a 70, 75. If anybody here is taking California and you just this time worked better. Okay, so now I'm going to do some demo of this. So I am using a California 90-minute PT. It's totally okay for us to use this. I wanted to do one where I thought that most people here probably would not have seen it before. I just dropped the PT in the chat. I dropped the link for you to view it. It's in the chat, and I will also put it on the screen. And I am going to get it pulled up in 1 second. Okay, I'm going to switch to my iPad, and we're going to walk through this process a bit. I'm going to demonstrate it, all right? So I'm going to be walking you through this. So give me 1 second. And I like to do this on the iPad, and I'll go back and forth with a blank Word document as well, just so that you can see what my typed answer would look like as we go. So give me just 1 second so I can get my Word doc up as well. So this is also a 90-minute PT, and I'm pretty sure that none of you have done this one before. So I thought it would be good to have a good fresh one. And also, to be totally honest, I looked at all of the freely available ones on the NCBE website, and there's quite a few good ones. There's quite a few good ones on there, but I wanted to sort of save those for you guys to practice from. And one thing I want to say is that there is one that is listed there, or that is available for free, that you should look at but not do. And it's In-Ray Community General Hospital. So on the NCBE website, they have like 5 years worth of MPT. So there's about 20 on there that are great. But one called Community General Hospital is one that I don't like. So because the library doesn't have any cases, it's just statutes, which is just, it's not bad, but it's kind of crazy. Okay. So first thing we have here is we have our task memo, right? We have our task memo. I'm going to write in black because that's what you guys will have. So I make a note of the 5 things that I want to identify. Again, it's tone, which is why I put these numbers, TAPOS, tone, audience, product, organization, special instruction. So here this says, defendant Sebastian Hughes is charged with murder after he fatally stabbed his uncle, Peter Galt, during a dispute over a Corvette car engine. Defendant asserts, so we're at the state attorney's office, so we're the prosecutors here. Defendant asserts he acted in self-defense. A centerpiece of our case against defendant is a recorded statement defendant made to detectives while he was in the hospital recovering from a stab wound inflicted by his uncle. Defendant originally moved to suppress the statement based on a failure to be given Miranda warnings. The judge ruled in the state's favor on that motion, so no Miranda violation. We're not going to suppress based on the Miranda violation, rather. Defendant now argues that the statement was not voluntary and therefore should be excluded from his trial. So I know I'm dealing with a voluntariness of this statement. The court decided that this new motion does not need to be briefed, but the court does want oral arguments. So we're doing an oral argument. Fine. I like this one too because I wanted to give you guys an oral argument. So please draft the oral argument I will give in opposition to suppression of the statement. Our success depends on our ability to marshal the facts. Do not start with a statement of facts as you would if you were writing a brief. Rather, weave the specific facts into your argument as they relate to each of the elements of the controlling law. Attached are the transcript of the recorded statement and a portion of the transcript where the court refused to suppress the statement on Miranda grounds. While you are not to address the Miranda issue, the court's characterization of the interview may be helpful to your argument. So what tone is this? We're writing a closing argument, so this is persuasive. Who's my audience? It's the court. The product is an oral argument. Organization? I don't know yet. I don't know what my headings are. I know I'm dealing with voluntariness, but I don't know what, they haven't told me. I want you to argue 1, 2, 3, right? If they were to tell you what your arguments are, that's your organization. If they were to say, we need you to analyze the elements of this case, then you would organize by the elements. But here, I haven't been given that. So it's a little bit tougher, which is why I wanted to do this one with everybody today as well. So organization, I don't have it yet. Special instructions, don't address Miranda, and don't do a statement of facts. Okay, so I am going to go over to my Word doc at the moment, and I'm going to do now my setup. So y'all should be able to see just a blank doc here. This would be your exam answer. So I'm just going to write closing argument, and I'm going to say good afternoon, and may it please the court. For the reasons established below, the court should not suppress the defendant's statement as it was given voluntarily. And that's really it. And then I'm going to have an argument heading, and I'm going to have a conclusion. My conclusion just sort of reiterates what I want. So for the reasons established above, the state respectfully requests the court deny defendant's motion to suppress. Well, actually, no, it's not request. We're doing a closing argument. The reason established above, the defendant's statement was given voluntarily. Because that's what we're dealing with, is just voluntariness. That's all I've got so far. I don't have anything to, I don't know what I'm arguing under this argument section just yet. Okay, so I've just got barely anything in here. That's okay. How many of you guys get a little bit freaked out when they don't give you the issues in the task memo? Tell me in the chat. I think it can be a bit scary. I definitely think it can be a bit scary. All right, so now we're going to go on to the next step. So we've done steps 1 and 2 already. We've already done steps 1 and 2. So then we go on to step 3, which is just to skim the file. And this is really quick. So when I'm skimming the file, I'm just kind of making note of what I have. So it's just a transcript of the pretrial hearing in this case. And I like to make a note, this is just what I have. So transcript. And I just read the first line, not even the first full sentence, but the first line of each big paragraph. So let's first deal with defense counsel's motion to exclude defendant's statement. Okay, so and this is on the Miranda part. Defendant moves to exclude the statement made. Okay, so I see what they're saying, and I see that this jumps out to me. When I'm skimming, I'm just looking to see what jumps off the page. So I'm like, okay, they're citing this case, Mincy v. Arizona. Okay, Does the state stipulate to these facts? We certainly do not stipulate to the allegations characterizing, okay? So, fine. So, and then here is the transcript of the interview, which is what's at issue. One other thing I want to mention with transcripts is I also like to look and see at, so this is going to be defendant's argument. And then here is my client. Whenever we're looking at a transcript, we're generally trying to say, who's going to use this piece of the transcript? If it's the opposing side, they're going to use it. If it's my side, it's usually going to be favorable to me. So, so prosecution. So I'm just labeling, I'm just trying to deconstruct. Everything is put in here in a relatively organized manner for you to be able to deconstruct it easily. So it's like when you're doing a puzzle. When you're doing a puzzle, we like to get little piles of things and put them together. That's what we're doing here, is try to figure out, what does this thing look like? So here is the transcript of the interview. So good evening, Mr. Hughes. I'm Detective Ray. Okay, and he's dead. Okay, so I just look at the big paragraphs. If you mean Peter Galt, yes, he's dead. Okay, we're starting the interview with Mr. Sebastian Hughes. Okay, so like this is the start. So I want to describe what I see. Mr. Hughes is shirtless. Okay, so this is like description of the defendant. Can you tell us what happened? I just see that and I'm like, okay, so here's going to be like the facts of what happened. So defendant description. I heard my mom crying. And then these are just some short paragraphs. Then it says, Peter and my mom were standing in the driveway in front of his van. Steve was furious. We argued. Then things got wild. Peter knocks me to the ground. I bent down and tried to pick up the wrench. Peter said, you're not going to do anything. Peter ran to the back doors of his van. So it's like this, just describing a fight basically between him and his uncle. I'm sorry, I guess I missed where your knife comes into the story. So here's the knife. Oh yeah, I got it from my work locker. Okay. I realized I had been stabbed only when I saw blood all over myself. I know this was all self-defense, man. If I had not stabbed Peter. Okay, and that's it. That's it. So I get a little bit of a sense of what's going on. This dude's in the hospital. I saw there was a mention of like drawing blood. They're describing him, but that's it. So I don't get a whole lot. But we keep the skim at that level because you're going to go back and read the file later on after we're through the library, right? Like this is why, like, when you're in law school, you're learning all the law, right? Because then you know how to apply it to a set of facts. So like this is where you're learning the law of what applies in this scenario. And then, when you get the file, then you apply it to a set of facts. So there's one case here. There's one case. Usually when there's one case, not always, but usually if there's one case, there's usually more. But if there's one case, there's going to be a case within it usually. So another point that I just want to mention here is when you have no statutes, it's just a case, and I'm not given the organization in the task memo, the organization is going to come from the library, usually. In most instances, it does. It doesn't usually when you are replying to the opposing side. If they tell you to write a response to a letter, you're going to get the organization from the letter. If they tell you to write a reply to somebody's motion, usually they'll give you the motion, and then you just take those headings and use them for your organization as well. So here though, now this is where I want to talk about understanding and extracting the organization from the library. Because everybody that was like worried when they didn't get the organization, this is where we've got to figure it out. And that's like my number one goal at the moment. So, and remember, I don't read the facts in the intro. I don't read the facts in the intro because it includes relevant and irrelevant information. But all of the relevant information, 99% of the time, is in the analysis of the case. So that's what I want to look for. So, and I'm not going to use a highlighter. I'm going to just use my pen, like the pencil tool, because for most of you, for a lot of you, you can't use highlighters. So I'm just going to show you what I label and mark up. So here it says, I'm going to start by skimming. It says, defendant Gerson Perdomo was involved in a single car accident. This is just facts. After a night of heavy drinking at around 2:45 a.m., this is just facts. Or you don't have to write facts out. You could just do like a big F for facts. Defendant based his defense on the contention that the other, okay. So this is really just facts also. Here, some of you might think it's getting into the procedural history because they're saying they based their defense, and then it makes you think, okay, this is what they talked about, what happened in court. That would be okay. But we still save time by skipping over these two big fact paragraphs. But as soon as, yeah. So defendant based his defense on the contention that the other surviving occupant, Marco Quinones, was driving at the time of the accident. Defendant moved pre-trial to exclude the evidence of inculpatory statements he made to the police officers. Near the end of the interview, defendant admitted he sometimes smoked marijuana and then said, maybe that day I was smoking. I'm not going to mess with you guys. I was driving Marco's car. Defendant argued that the admission of his statements violated his Fifth and 14th Amendment rights to a fair trial. So now this is where we really start to pay attention because we're getting into the issues of the case. He claimed it was error of constitutional dimension to admit statements he made to officers who interrogated him in the ICU of the hospital while he was recovering from surgery and heavily sedated with narcotic pain medications. So don't get caught up in the fact that this is the defendant's argument. You need to know this is what the defendant argued. What I care about is what did this court say about that argument? It says defendant suffered severe traumatic injuries to his chest area. Several of his ribs were fractured. He underwent emergency surgery to remove his spleen. He also had some bleeding in his brain. So this guy's got some pretty bad injuries, right? Traumatic injuries to his chest. Then it says 4 days after the incident and defendant's surgery, medical personnel in the ICU of the hospital finally granted Officer Laubischer and his partner, Officer Jensen, permission to speak to defendant. Medical personnel directed the officers to keep their discussion brief around 6:30 a.m., so it's early in the morning. The officers interviewed defendant in the ICU. The interview was tape recorded. Defendant was lying flat on his bed, recovering from the splenectomy, broken ribs, and head injury. He was in obvious pain. Defendant had received his last pain medication 5.5 hours earlier. He was still connected to intravenous solutions and monitors. He had been on a vent since the surgery, but this device had been removed the day before and he was breathing on his own. Defendant's speech was slow and deliberate, but not slurred or overly raspy from the intubation. The officer's questions were also slow, subdued, and deliberate. The interview, with numerous pauses, lasted approximately 20 minutes. The officers questioned defendant about the events occurring before and after the accident. Defendant's answers were responsive to the officers' questions. Most significantly, according to Officer Jensen, who was present and later transcribed the tape, defendant admitted he'd been driving the car when the accident occurred. And yeah, Marchi, so somebody asked, are you supposed to read full paragraphs once you get to procedural history? Yes, that's when you start to read. So I'm just, this is a lot of facts, but it was after the procedural history, because here's the procedural history. And then it goes back to facts, but it's telling me that these facts are a bit more relevant because they're after the procedural history. Sorry, I should have labeled these. All right, and then it starts, so now we're not talking about, we're right here. Now we go from talking about what happened in this case, just like the factual background of it, and then we get to a rule. We know it's a rule because it says a statement is involuntary if. It's giving something that you can apply to anything else. So here is a rule for voluntary or involuntary. So here's the rule. A statement is involuntary if it is not the product of a rational intellect and free will. The question posed by the Due Process Clause in cases of claimed psychological coercion is whether the influences brought to bear upon the accused were such as to overbear the petitioner's will to resist and bring about confessions not freely self-determined. So, and you see here how they number this? This is your organization. So in the next paragraph, in determining whether or not an accused's will is overborne, an examination must be made of all the surrounding circumstances, including the characteristics of the accused, including such factors as the defendant's maturity, education, physical condition, and mental health, including mental acuity. And 2, the details of the interrogation that indicate coercion, which include the length of the interrogation, the location of the interrogation, and the interrogation's continuity. So this is probably how I'm going to organize 1, 2. I'm going to continue to read though. Additional factors that might indicate coercion would include whether the officers dominated or controlled the course of the interrogation, whether they allowed the defendant to tell his story, then asked follow-up questions to clarify the details, whether the questions were open-ended and neither aggressive nor particularly accusatory in nature, and whether there is evidence that the officers had or drew weapons or otherwise employed threatening or intimidating or interrogation tactics. No single factors are dispositive. So here's some additional factors. So this might be a third issue. So this is a rule. This is a rule. These are additional factors. So we're going to include all of the surrounding circumstances. So I'm going to look at, right, the characteristics of the accused and the details of the interrogation. When I first looked at this, I was like, okay, there's issues 1, issues 2, and I couldn't decide, is this additional factors part of the details of the interrogation or is it separate? And honestly, it doesn't matter. You can do it either way. So you could do one, you could do two headings, or you could do three. So defendant asserts there are numerous parallels between his case and the factual circumstances of Mincy, sufficient to find his statements involuntary and require reversal of his convictions. So surrounding circumstances, and you see they go about and they say characteristics of the accused. Oh, I said I wasn't going to use that. So characteristics, right? Or I would just write issue one. And then they give us this other case. They give us Mincy, and they go in depth into Mincy. And they say, you know, in Mincy, what happened? And they walk through it. And this is basically giving us our second case. So Mincy we can treat as an entirely additional case that we have in the library. So, you know, in Mincy v. Arizona, Mincy was shot in the hip by police officers in a raid on his apartment. Mincy was transported to the hospital where he received emergency treatment. And I'm going to write Mincy. Mincy, when he arrived at the hospital, he was almost to the point of coma. The shot caused damage to the sciatic nerve and partial paralysis of his right leg. In the emergency room, tubes were inserted into his throat to help him breathe and through his nose into his stomach to keep him from vomiting. A catheter was inserted into his bladder. He received various drugs, and medical personnel attached a device to his arm so he could be fed intravenously. Mincy was then moved from the emergency room to the ICU. Around 8 p.m., so like this is talking about the characteristics of the accused. And then they start talking about what happened in the interview. So around 8 p.m., a police detective came to the ICU. So I'm going to say interview Mincy. I'm just trying to like make it easy for myself to find the various components while, you know, later on, because I'm going to come back to this stuff. So around 8 p.m., a police detective came to the ICU to interrogate Mincy. The detective told Mincy he was under arrest for the murder of the police officer. He gave Miranda warnings to Mincy and started questioning him about the activities and shooting at his apartment. Mincy could not talk because of the tube in his mouth. He responded to the detective's questions by writing answers on pieces of paper. The detective continued to question Mincy until almost midnight. During the interrogation, Mincy repeatedly asked for the interrogation to cease. Several times, Mincy requested the assistance of counsel before responding. He complained to the detective that the pain in his leg was unbearable. Some of Mincy's written responses were incoherent and on their face showed he was confused and unable to think clearly about the events at his apartment or about the interrogation. And then the Supreme Court concluded Mincy's statements were not the product of his free and rational choice. So this is what the court says the holding is in Mincy. So it was that it was involuntary. And remember here that it was talking about the characteristics of the accused. Or I might just write like issue one instead of writing all this stuff out. Just label it issue one. So they said they were not the product of his free and rational choice. To the contrary, the undisputed evidence makes clear that Mincy wanted not to answer Detective Hurst. But Mincy was weakened by pain and shock, isolated from family, friends, and legal counsel, and barely conscious, and his will was simply overborne. Due process of law requires that statements obtained as these cannot be used in any way against the defendant at his trial. And now we say, like the situation in Mincy. So now they're talking about, here is the analysis of Perdomo, which is this case. Here, defendant was questioned while lying in a hospital bed in the ICU. As in Mincy, no family or friends were then with him. He was recovering from surgery for the injuries he received 4 days earlier. Intravenous tubes were still attached to his body. Defendant had been receiving narcotic pain medication since admission to the hospital. According to the interrogating officers, defendant appeared to be in pain and also appeared to still be under the influence of the narcotic pain medication. However, and as soon as you see the however, they're going to come to the opposite conclusion as Mincy. So in this instance, maybe you don't know that, but usually when they say all of this stuff that is like it, and then they say, however, they're going to come to the opposite conclusion. So it says, however, this is where the similarities end. Unlike what occurred in Mincy, defendant was not interrogated within hours of his injury and not interrogated only a few hours after receiving medical treatment. Also, unlike in Mincy, defendant was not interrogated while going in and out of consciousness. In this case, the officers were not permitted to interview defendant until 4 days after defendant's surgery. Hospital personnel did not permit the officers to talk to defendant until they determined he was alert, oriented, and could obey commands, as indicated by his medical chart. By this time, defendant no longer needed the assistance of a respirator, and medical personnel had removed it the day before the interview. On the day of the interview, hospital staff determined defendant's condition had improved sufficiently so that he could safely be cared for in a regular hospital room. At 8:30 a.m. and 2 hours after the interview, defendant was moved out of the ICU, taken off intravenous pain medication, and thereafter given oral doses of Vicodin for pain as needed. The evidence showed defendant was probably still under the influence of pain medications, although the effect of the morphine he had received 5.5 hours earlier had likely diminished over the hours. Nothing on the tape shows defendant's thinking was impaired by the medications. Defendant's speech is slow and deliberate, but is not slurred or incoherent. Each of defendant's answers is appropriate to the question asked. In some instances, his answers were detailed. For example, in the name of the security company for which they all worked, defendant stated the name for the officer, spelled out the company name several times, and even recited the company's telephone number. At the beginning of the tape, it appears defendant was even alert enough to attempt to deceive the officers. So I'm like, oh, when they give me something like that, when they're like, oh, he even tried to deceive, then when they say that, then I'm like, all right, so maybe in my case, there's going to be an argument like that. They're like, he was alert enough to attempt to deceive. He initially told the officers the night of the accident that he'd been driving his mother's Nissan alone and without passengers, but he later acknowledged being with Rodriguez and Quinonez's mother's Honda. So the however indicates that they're going to come to like the opposite conclusion. Like if it sounds like it's going one way, if they say however, it's usually going to go the opposite way of what you might think, which is what they do. So here they say the court holds here that the characteristics of the accused demonstrate that this was not involuntary. We have to look at both. We have to look at both the characteristics of the accused and the details of the interrogation to make that determination. But here, the characteristics show that it was voluntary. So at least with respect to that part, So then they do the same thing where they go through, and I want you guys to practice this one because I'm going to, we're going to send out the answer with this. I'm going to give you guys, I don't like to say this because please don't email us asking for it. We will send it out, but it'll take my team a little bit of time tomorrow to send it out. But I'm going to send you guys my answer to this PT and you can see what I did. So you should practice this on your own. This is a great one to practice. But you see, now they talk about the details of the interrogation and they talk again about Mincy. And then they talk about the case here. And they determine that they say that it cannot be deemed involuntary, i.e. it was voluntary. It was voluntary. So you guys should practice that reading so you can see what it looks like. One thing I want to point out here is some people might get a little bit like, have a little bit of heartache because they talk about so much. They give so much of the facts. Here for the first part, for the first issue, this is really the analysis because this is sort of their summary. This is why they say that this is not, they're distinguishing from Mincy where they said it was involuntary on this component, on this part of the test. But here I'm going to say, yeah, so in Mincy, it was involuntary, or there was coercion. Here, it's not, and this is why it's not. So analysis, issue 1. So a couple of things. So initially, when I first got into this, I thought, are there 2 issues or are there 3? The fact that they broke it up into 2 tells me that you really just need to do it into 2. But if you had done it as 3, that's okay too. But I think these additional factors really go to the details of the interrogation, especially when you look at what the factors are. Thank you, Dominique. Yeah, there's the link. Thank you, Dunya, that also posted it. All right, so I'm going to go back to my answer. I love when people chime in and help me out for posting those links. Thank you. I appreciate that. So I'm going to go back to my answer and I'm going to put in my headings, right? So I'm going to say the details of the characteristics of the accused demonstrate the statement was given voluntarily, and the details of the interrogation demonstrate the statement was given voluntarily. So those are the 2 issues. And then what I would do is I always make an annotation, RPACC. I always make a note because every PT may have all of these as paragraphs. So I have rules, I have the rule proof. I'm going to have usually several analysis paragraphs. So you could have several of these. If you have a counter argument, you're going to have a counter argument in a new paragraph and then a conclusion paragraph. So I would have each of these. So what I'm going to do is I'm going to say, okay, for each of these issues, I'm going to use both Mincy and Perdomo. So here, I do like to put this shorthand in here. So my rules for this are going to come from Perdomo. My proof, I'm going to do a proof of both Mincy and Perdomo. And here, I know that I'm arguing for a particular outcome. So I'm going to analogize to Perdomo and distinguish from Mincy. I don't know what my counter argument is yet, but I have one. And then it's going to be the same here. So your rules again are going to come from Perdomo or Perdomo Mincy. And then you're going to analogize to Perdomo, distinguish from Mincy. Then I would just copy in my rules that are stated that I had identified. I would just copy in the rules and then I would draft my rule proofs. I'm not going to go into drafting just because we're keeping this to an hour tonight. And I have a ton of videos that do explain that so that you can watch. But I just really today wanted to show you because a huge hurdle is figuring out when they don't give you the issues, what do you do? And then how do you identify it in the library? Here they gave you the headings, which made it really helpful, but also then kind of digging through the heading and knowing what you're going to do with it. If y'all want more practice with the PT, you should absolutely come to the checkup I'm doing this Sunday. And if you need instruction, it is not too late to get the book or to get the course. I am going to drop my answer to this PT in the chat right now. Give me 1 second. I'm dropping it in the chat so you can download it from there. So if you just click on the PDF icon that is in the chat, you can download it. This Sunday, we're doing a PT checkup. This Sunday, we're doing a PT checkup. So you should join that. It's $25, 2 PTs, 3 hours. It's proctored by my really wonderful assistant. And then I will be there to teach you what you needed to do in those PTs. So I walk you through them. So it should be really, really helpful. And there will be 2 MPTs also. So there'll be 2 MPTs. And then, yeah. Oh, for those of you that are here live, we have a little bit of a discount code. And yes, even if you don't feel like you can completely do a PT yet, come and do it and try, see where you get hung up. You know, it's a really, really great time to practice and maybe you'll do better than you think you will. So here you can get 10% off. I think this is for orders of, I think $100 or more. So if you want to do that, if you want to sign up for that, it doesn't apply to any tutoring or grading or the mock exam. So anything where it's like very service intensive for us, you can't use the discount. Yeah. So definitely join us and we'll send out this code to those of you that are here. Let me drop the PDF in the chat again. And we will email it. If you don't see it right now, we will send it out in an email tomorrow afternoon, but please don't, my team gets overwhelmed. I am not doing any more PT sessions. This is it. This is the last one I am doing for the bar, for the upcoming February bar. The model answer, Rebecca, is in the chat. It's posted as a PDF. It's not a link. It's a PDF you have to just click on. And I will make it a little bit easier so that you guys can't see what other people are saying by dropping it. So I just dropped it one more time. I think with the book, it has to be $100 or more, and the book is $99. So I think if you did like the book and the checkup or the book, then you can use it. Then you can use the code. Let me give you guys the code one more time. It's right here. And this expires at the end of the day tomorrow. Thank you, everybody. And the book includes, if you look at the description on the website, it includes a bunch of PTs. It includes my marked up file and library. It includes, I give you detailed instruction on how to write the amount, like every step of writing the PT, etc. And yeah, Sawa, it's this Saturday. It's this Sunday. It's this Sunday. No, the UBE book and the MPT course are not the same. They're not the same. It's sort of like having a textbook and a course. They're not the same. And we'll send out links to this in the follow-up, but it's called the Best PT Book. And this is Checkup 3. It's Checkup 3 that's this Sunday. And Mubashar, if it's not opening, we're going to send it in the email tomorrow as well. We're going to send an email out. All right, everybody. Thank you so much for joining. Hopefully see you in the checkups or in class. If you have questions, please feel free to reach out. The PDF that I posted just recently is my answer. The original one I posted a while ago is the state bars. Mine has my logo on it. All right. Thanks, everybody. Thanks for joining. Good luck studying. You have plenty of time. You're in good shape if you got to get all the PTs under control. So you've got plenty of time. Thanks, everybody. Bye-bye.